We'll just give everybody a minute or two to allow everyone else to get on. We'll start at 12 o'clock, so we'll start in about a minute or so. Okay, hello everybody and welcome. We're going to begin our webinar now. So today's topic is on financial and legal strategies about acing your association budget. My name is Carol Koransky. I'm a partner here at Wilkin and Guttenplan. We want to welcome you to our continuing series of webinars. The webinars are geared towards board members, property managers, and other professionals to help give guidance in many topics of interest. Our speakers that we have with us today from our office, Mohammed Salyani. He's a principal with Wilkin and Guttenplan. And we also have Scott Penick, Esquire, from McGovern Legal Services. And I'll give you a little bit of information on both of those speakers before they give their part of the presentation. So just a few items of housekeeping that I'd like to go through. First of all, to ask any questions, please use the questions pane in the GoToWebinar dashboard on your screen. We will try to answer as many as possible at the end of the presentation. Again, just type them in as you hear our presenters speak, and then we'll be accumulating them, and we will try to answer as many as we can at the end of the presentation. The webinar is being recorded, and we will upload to our website, www.wgcpas.com, at the end of the presentation. Additionally, a PDF version of the webinar will be emailed to all attendees. At the end of the webinar, we'll be showing a slide that also will have the contact information for both Mohammed and Scott, if you have any questions that you feel were not answered or if you'd like some follow-up information. Lastly, we'll be sending a survey after the webinar via email. Please return it. We do value your comments. Again, as I said, this is a continuing series of webinars. We'd like to know what you thought of the webinar and suggestions for future webinars. Just as a note, we do have our next webinar will be in December, and we'll be reviewing our survey of financial results. So to start off, before we introduce the speaker and get going, we just have a polling question just to get a little bit of information, and you're going to see how this polling question comes into play later. But when was your last reserve study performed? A, within the last 3 years, B, 3 to 5 years, C, 6 to 10 years, D, more than 10 years ago, and E, what's a reserve study? So if everyone can please answer that, and then as our speakers go on, you'll see how that becomes important. So while you're answering, our first speaker today is Mohammed Salyani. I'm sure most of you know him already. He's a principal here at Wilkin and Guttenplan. He joined our firm back in 2001. He specializes in providing audit, review, and compilation services to not-for-profit organizations, closely held businesses, and real estate entities such as community associations. For his real estate clients, he also often performs consulting services and agreed-upon procedures, including fraud detection, forecasting, and transition reports for sponsors and management companies. Prior to joining Wilkin and Guttenplan, Mohammed worked for a public accounting firm in Kenya where he performed audit work for hotels, banks, and closely held businesses. Okay, so our survey results are in. About 56% of you have had surveys done within the last 3 to 5 years, and about 27% have had surveys, reserve studies done in the last 3 to 5 years. And only about 3% have been older than that. So Mohammed, why don't you go on and start your presentation and discuss how that's important and relevant in preparing your budget.
Thanks, Carol. Hi, everyone. For those of you who know me, I love to talk to people, and I'll talk to people for hours on the phone or when I meet them. But during budget season, I tend to get a little apprehensive because I don't know what it does to people, but sometimes it does bring out some interesting information. Anyway, I'm just kidding. I'm always available anytime you want to call me. We're going to go through some budgeting guidelines here, and we'll talk about the replacement fund a little later on while I'm going through my section here, and even Scott will touch on it later on. So we're going to first talk about basic budgeting rules, and then we'll touch on certain special areas of concern, such as bad debt, prior year deficits, unpredictable expenses, the contingency line item, the replacement fund study, the deferred maintenance fund, and then other sources of revenue. So for your basic budgeting guidelines, it's extremely important that you do your homework. Where do you start? You start with your prior year's audited financial statements. Review the prior year's audited financial statements and also look at the recommendations that your auditor gave you. Does the association have a deficit? Or are there certain line items that you're not budgeting enough? There's absolutely no point in having a budget that's not realistic. So look at what you have from last year, and that's kind of your first starting point. Then what you need to do is you need to get your current year's year-to-date numbers from your monthly management report that you get. Our suggestion is to put all this into an Excel spreadsheet where you have all your account line items, and then the first column after that is your year-to-date numbers. The next thing you do in the next column is to have an estimate of the expenses for the remainder of the year. Keep in mind items that are cyclical and dependent on the season. For example, we're now in September. Most likely your pools have already been closed. You're not going to have any pool expenses, but you will have items such as the closing of your irrigation system and things like that. So you have to keep that in mind when you're estimating the remainder of the year expenses. In your third column, you then have the sum of these two columns. You add them together and you come up with your total expenses expected for the whole year. Now, while you're estimating your numbers, please be conservative. Make sure that you're estimating realistic numbers. Now, the next column is going to be what you anticipate is going to be your budget for the next year. The first thing you need to do is to obtain signed contracts for the next year. Fixed costs, for example, landscaping, pool expenses, pool management, management fees. Make sure you have a signed contract for all these line items, and you put those in. Then once you have that in there, and based on your prior year actuals, you start estimating annual costs for the next year. For example, let's say you have landscaping expenses. You do have a contract for landscaping, and year to date you've spent about $74,900 on your landscaping expenses, which is 7 months worth of expenses plus your 7% tax. Your landscaper has told you that you're going to have a 5% increase on your landscaping contract for the next year. You have 2 months remaining on your landscaping. That's about $10,000 per month plus tax. So that's about $21,400. The landscaper then tells you that due to certain storms that we had during the year, you're going to have to spend about $30,000 for fall cleanup, which is normally about $20,000. So once you add all that together, you come up with an estimate for the year of $126,300. Now, your fixed contract for next year is going to be $101,115. That's your contract plus the tax plus the increase. To be conservative, you normally spend about $20,000 on cleanup. You spent $30,000 this year. Let's go in the middle and put it at about $25,000. So you add that together, you come up with $126,115. You be conservative and you put in $127,000 for next year's budget for landscaping expenses. Now we move on to special areas of concern. One area I know that everybody really gets concerned about is bad debt. What you need to do is you need to look at where you are for the current year. Some associations will note that their bad debts, their total receivables are increasing during the year. Some might see that they're actually coming down. If, for example, you have rent receiverships or other things like that, again, Scott's going to talk about that. Or you might have some settlements that you had in place during the year. So make sure you're aware of which way your receivables are going. You need to be really conservative as far as bad debts are concerned. If somebody is not paying you what they owe you, what's the likelihood that they're going to be paying you going forward? So get your aged receivables and look at all the unit owners that are over 90 days old. Now, in your budget, you're not putting a line item for what they already owe you. You're putting in a line for what you anticipate that they're not going to pay you for next year. So this is how we suggest you calculate your bad debt expense. Take your monthly fee for all those units that are not paying you their maintenance fees. You add the monthly late fees or the monthly fines that you have, that you charge them every month. In case you might have a special assessment that's going on, add that in there, multiply that by 12, and then add on the legal fees. So let's have an example here. If you have 2 units that are not paying you and the monthly fee is 100, your late fees and fines are 20 every month. So every month you're not collecting $240 from them. You add that up for a full year, that comes to $2,880. Now you take into account whatever legal fees you're spending on those 2 units to try and recover that money. Maybe it could be $500, it could be $1,000, it could be $2,000. You need to be realistic. You add that to this number, and that's the number that you should put in at least for your bad debt expense for the next year. Also, you should look at what you had as bad debt for this current year and compare it to what the increase in your receivable is to see how realistic you've been as far as your budget for this current year is concerned. Let's talk about prior year deficits. So if an association has prior year deficits, if you don't know whether you have prior year deficits, look at your prior year's audited financial statements and the statement of changes in fund balances, and you'll be able to see whether you have deficits or not. If you have a deficit in your operating fund, you need to take care of this. It's highly likely for associations that have a deficit, they also have inter-fund balances on your balance sheet, because what's happening is you have a deficit in the operating fund, you need the money to pay for your day-to-day expenses, so what you're doing is you're borrowing from yourself. And the most likely place that you're borrowing from is the replacement fund. So you're not highly likely that you're not paying the replacement fund and you have an inter-fund balance. So how are you going to pay this deficit that you have from the prior year? You also need to take into consideration where you're at in the current year. So in that column that we talked about in the Excel spreadsheet that we mentioned earlier, you're going to look at the third column and see at the bottom of the column whether you have a net deficit or a net surplus that you anticipate by the end of the year. You add that to the deficit that you had from the prior year, and that's your expected deficit at the end of the year. How are you going to pay for this? There's a couple of ways that you can do this. One is, whatever that number is, you add it to your maintenance fees for the current year when you're creating the budget. The other way to do it is you decide to have a special assessment, and you put in a separate line item in your income section of the budget. Now, also, to make sure that your budget is balanced, what you do need to do is to have a line item on the expense side that shows deficit funding. In certain rare cases, I have seen associations do a budget where it ends with a surplus, but that surplus is being used to pay for the deficit. my recommendation is it's better to have a line item for the deficit in the expense section because it just brings the budget down to zero, and that's what you're aiming for. Now, if the association has a large deficit that's too big to take care of in 1 year, you can still look at it in a way that you can recover the deficit over 2 to 3 years. Spread it over 2 to 3 years. Make sure that you're being realistic as far as your other line items are concerned, and the anticipation is that you'll be able to cover that deficit over that period of time. And once you cover the deficit, you're creating a kind of surplus. So you're covering the deficit, you're adding money to your operating fund cash balance, and that money is then going to be used to pay off the interfund balance or the loan kind of that you've taken from the replacement fund. It all ties in together. So we're now going to talk about some unpredictable expenses. The first one we have is snow. This has become such a word that sometimes when I hear my daughters mention it, I almost want to tell them, you're too young to say that. So anyway, snow is a very difficult item to budget for. What I suggest that you do is look at your past 5 years. Look at how much you've spent on snow for the last 5 years and average that. That's a good starting point. Some associations I actually have a fixed budget or a fixed contract for snow, and they're in a better position where they know what it's going to cost. Repairs and maintenance. Look at what you've spent in the past few years, and based on that, also come up with a budget for repairs and maintenance. It's always better to budget more than less. Now, you also need to keep in mind the effect that one might have on the other. For example, if we have a lot of snowstorms, you're going to have a lot of snow on the roofs. You might end up having some ice damming, which could result in water leaks and increase your replacement fund, your repairs and maintenance expenses. So keep all that in mind. During the year, make sure you're monitoring these expenses carefully. It's always easier if you want to put in a special assessment. It's always easier to put in a snow assessment when it's still a little cold out there, there's still a little snow on the ground, rather than in August when people are sitting by their poolside and they're talking about what snow. The contingency line item. I have a lot of people who ask me, why do we need that? The whole purpose is for contingency is for unforeseen or unpredictable expenses, like the snow. For example, if you do go over during the year, you can always fall on contingency to give you some protection before you decide to do a special assessment. Unpredicted projects such as drainage work, you didn't expect to have to do it. You now have an issue because we had a lot of rain during the summer. You need to do some drainage work. It's not in your replacement fund. You fall on your contingency line item to be able to cover that expense. How much do you put in for contingency? Probably about 3 to 5% of your total expenses before the allocations to the replacement fund and the deferred maintenance fund. So now we're going to talk about the replacement fund study. So I understood that about 2/3 of you have had a study done in the past 3 to 5 years. Are you funding in accordance with the study? Usually studies will give you a couple of different scenarios, a couple of different options to be able to fund. You have the full funding, you have threshold funding, and you have baseline. And sometimes within threshold, you might have a 5% threshold, you might have a 10% threshold. And are you funding in accordance with that? If you're not, you really need to come up with a plan on how to get to where you need to be funding. For those of you that have studies that are over 5 years old, I seriously suggest strongly that you have a study done in the next year. If you don't have the time to do it now, put in a line item for engineering expenses so that you have a study done. There's 3 different types of study that you can do. You can do a full study where they come in and measure everything. You can have an update with a site visit where they look at the items, or you can have a paper update. Look at what is applicable for you. Have a study done. Once you have the study done, please meet with your engineer. Discuss the study with your engineer. come up with a solution that you agree to, that the engineer is okay with. You could even do a step-up basis of funding where you increase it every year slowly to get to where you need to be. The deferred maintenance fund. The name deferred maintenance fund, I don't know who came up with this. It almost sounds like you're deferring the maintenance, but you're not. You're deferring funds to be able to do maintenance that occurs less frequently than annually. So it's a kind of smoothing out the expenses. For example, you need to paint. It's going to cost you $50,000 to paint every 5 years. You put aside 10 every year. In the 5th year, you have $50,000 so as to be able to do the painting. My suggestion is if you don't have a fund, put in one. And if you do have a fund, have a study done. When your engineer is coming in, it's very easy for them to come up with items for your deferred maintenance while they're doing the replacement fund. Don't use the deferred maintenance fund as a slush fund. That's not what it's for. It's for specific items that occur less frequently than annually. So now we've covered all the expenses. We've got to talk about some of the other resources or revenue resources that you have. For example, membership fees or working capital. Associations that are a little older may have decided to use working capital in the operating fund rather than putting it into the statement of changes in fund balances. Some associations might have roof rental income. Some associations might have this marketing fees from companies such as Verizon or Comcast. Are you renting out the clubhouse? What kind of income are you getting? If you are getting income from non-unit owners, then there could very likely be tax implications on the net income once you've charged certain applicable expenses. Please make sure you take the tax into consideration when you're determining what the net income is for each of these line items. So now we've done all our expenses, we've done all our other sources of income. The last line, of course, is the maintenance fees, which is the net of everything and the allocations after you've taken out all the income. That's your maintenance fees. Sometimes it's a hard pill to swallow if you have to increase it. But, you know, let's face it, you're living in an association. This is what it's going to cost you. You pay as you use. So that's my presentation. If you have any questions for me, I'll answer them later on once Scott is done.
That's right. Thank you so much, Mohammed. I'm just going to do just one follow-up comment. Mohammed talked about the engineering study and when you have one done and budgeting for it and making sure to talk to your engineer. Just for some more information and detail on that, we recently just did a newsletter and talking about having your engineering study in sync with your budget. And that goes into a little bit more detail about some things to consider. So I would just suggest that if you do have questions on that, you could look at our website and look at that article. Okay. So thank you, Mohammed, again. Now we're going to talk about some legal strategies and some legal ways to handle the budget. So the first question, before we introduce Scott, we have a polling question for you. And the question is, how much has your association's insurance premiums increased over the past 2 years? Insurance is a hot topic, and just to see where you stand with that. A, less than 10%, B, 10% to 20%, C, 20% to 30%, D, 30% to 40%, and E, over 40%. All right, so while everybody is answering the poll, let me introduce to you our next speaker, Scott Penick, Esquire. He is, was admitted to practice law in the states of New Jersey and New York and the chair of McGovern's corporate group. Scott joined McGovern Legal Services in January of 2010. Along with representing business clients, Scott handles matters involving all aspects of community association law, including litigation, collections, board governance, contract negotiations and preparations, ADR, municipal service agreements, etc. I think you got all of them in there.
It's a long list.
It's a long list. You encompass everything. He has been the lead attorney on unique cases ranging from claims of adverse possession against an association's common property to the effects of tax liens on unbuilt condominium units, demanding equitable utilities billing practices by municipal authorities, and even restoring expired governing documents years after their expiration. Scott was also a leader in crafting post-Sandy reconstruction agreements to address the unique issues involved with the storm and insurance-driven repairs. He takes pride in implementing the firm's philosophy of solution-minded advocacy through crafting creative solutions to conflicts, which save clients time and money. So, Scott, thank you so much for coming with us today.
Sure, thanks for having me.
So let me just let you know where we stand on the insurance. And really, about 33% had less than 10%, which is great for those people. But about 50% had insurance premium increases of 10 to 20%. And the remainder of people had insurance increases of greater than 20%. So, Scott, maybe you'll be able to talk a little bit about that going into your first topic.
Right. So there's obviously two ways to do better on your budget, and that would be reducing expenses or increasing revenue. And believe it or not, your attorney may be able to help you reduce one of your biggest line items, and that's insurance. We've actually come up with a lot of these strategies from talking to insurance brokers in the industry who recommend these to their clients as well. They're things we've been doing for our clients, and we've seen them help their premiums not go up as much. This is not a story of fairies and unicorns. It's not going to make your premium go down now, but it might reduce the increase in the future. And just to let you know, I'm a real attorney. I need to give a disclaimer that this is just for educational purposes. I'm not providing any legal advice here. We're not establishing an attorney-client relationship or anything like that. Just a little bit of education, but I would love to talk to you later if you have more questions about what we're discussing today. Now, one of the things we've seen a lot of clients, in fact, I got an email on it yesterday, have insurance problems with are water claims. So as these claims mount up, your community starts to look like a risk with regard to insurance, and your premiums are going to rise. One of the ways to fight that is to institute a requirement to replace water heaters on a regular basis. It doesn't have to be 10 years, but 10 years is pretty much the standard. We know how long water heaters last. And if you wait to replace it until it leaks, like the last time I replaced my water heater, you're going to have water everywhere. And that is one of the largest sources of claims for property damage that we see associations have that aren't related to natural disasters and things like that. It's leaking water heaters. Not only is it destroying the unit that the water heater was in, it's destroying the unit downstairs if this was an upstairs neighbor. If you require those water heaters to be replaced on a regular basis, you're going to reduce the amount of claims for water loss, and that's going to keep your premium increases down, or at least it's going to help. Another way to do that, to attack the water issue, is to require steel hoses and backflow preventers on washing machines. If you've ever bought a washing machine, you look at what comes with it. It's basically a cheap garden hose. Taking the water into the machine, and then also where the water is getting expelled from the machine. Those don't last very long. They crack. They're a lot more subject to leaking than some of the nicer hoses. Is a small investment for unit owners to make. It's saving them a headache. It's saving you an insurance claim. It's hopefully reducing future increases in your insurance premiums when you have these steel hoses put in place and backflow preventers. And this really helps with second homes, which goes along with a couple of bullet points down, the minimum temperature resolution, which I'll get to in a second. I'll keep going in order there. Because people aren't home, so these leaks result in much larger claims, a lot more damage. If you have chimneys and fireplaces, you have got to have a resolution mandating regular inspection and cleaning. Usually that's on an every 2-year basis. It's a very real fire hazard. It's not just one more thing for the manager to have to worry about and collect those forms every year, and for everyone to spend their $50 or $60 or however much it costs to get their chimney taken care of. This isn't just, by the way, to save money. This really saves lives and property. You don't just have a new floor to replace when the chimney catches on fire. As anyone who's been through this knows, you've got a whole unit, maybe more, to replace, especially critical and connected townhomes and condominiums. Same story with dryer vent cleaning. A lot of people are dismissive about the risks here, but it's very real, and there really are fires. In a community that we represent, I was recently at a meeting where one of the board members said that he had just had his cleaned and was told that two more uses of his dryer and he was probably going to have a fire. I don't know if that was exaggeration by the guy that came out there cleaning, but it's a real thing, really can cause a fire, and that's going to shoot up your insurance premiums. If you have fires, if you don't have these kinds of rules in place, you're going to look like a risky bet to the insurance carrier. The minimum temperature resolution is really for the winter time. What a lot of you may not know is that most of your insurance policies require a minimum temperature to be maintained at all times in the unit. So you leave for the winter, you close up, you turn the thermostat, you turn the heat off, and we have frozen pipes. Even if a unit's been winterized, the individual pipes in that unit, a lot of associations have common fire suppression systems and lines that are going through every unit. These common lines can freeze, and I've seen $50,000 cleanups because somebody didn't keep the heat on. It's usually about 58 degrees. You need to figure out what your policy says. You need to have a resolution in place so you don't have an uncovered loss in the event of a pipe break and that kind of situation. And finally, and I will move faster through my other slides, the New Jersey legislature has created the opportunity for your membership to vote in a tort immunity amendment. A tort immunity amendment protects the association from claims based on negligence from owners. It's not going to protect you from tenants, residents who aren't owners, and things like that, but it does minimize the claims from slip and fall accidents and that kind of thing. It's really what it's targeted at, and carriers like to see it, and it really helps with the slip and fall issue. If you're in a community that has had that a lot, this could be a stopgap to try to put in place to stop those premiums from jumping up. Going on to the next slide. So sometimes insurance losses result, or losses related to insurance coverage, result in unexpected expenses, not just premiums going up, but mid-year expenses. So one of the ways that associations can address this, and one of the newest things that some of our clients have started doing, some of the insurance brokers have started recommending, is an amendment establishing strict liability for unit owners who cause uncovered losses. Or uncovered losses that stem from their unit, maybe their water heater. This is to deal with the issue of having to establish that there was negligence on the part of the unit owner. Some unit owners are smart or sneaky, however you want to look at it, and they started to push back against associations' demands to pay for the deductible primarily, or cover other losses, and so creating a strict liability situation, the intent there is to eliminate that argument about negligence, eliminate the need to prove negligence with an expert. It just makes it more expensive, and a lot of times people give in and they just don't want to spend the money. They don't want to go through the time, so this makes a very clear-cut rule. A little bit softer, but a great tool if you can't get an amendment, is an insurance deductible resolution that will lay out who's responsible for the association's insurance deductible in different loss situations, depending on what property was damaged, depending on who caused the damage, where the damage started. This resolution, I say it's a little bit like premarital counseling. It just establishes the rules ahead of time, and that can stop a lot of fights later on. Right? If you kind of know what the rules and expectations are before the event happens, it's a lot easier to deal with the event when it comes, like who's responsible for the insurance deductible. And finally, requiring owners to carry insurance, right? It's all fine and dandy that the association or the unit owner is responsible for your $10,000 water deductible, because that's where a lot of them go. It doesn't do much good when the person doesn't have $10,000. But what most homeowners, or especially in condominium associations, should have, and we can mandate that they have, is association deductible coverage in their policy. It basically lets them turn a $2,500 or a $5,000 or a $10,000 expense into a $1,000 usually expense, because they end up paying their deductible because they have insurance to cover the association's deductible in the event they're responsible for that deductible. The point is, it allows you to actually get paid as an association, or allows you to actually ensure that the work gets done, because the homeowner has now reduced the expense to something most people can manage, an extra $1,000, right, or something like that, whatever their individual deductible is. It's a great tool to ensure that the money is actually going to be there to cover that deductible once you have either the amendment for strict liability or an insurance deductible resolution that lays out who's going to be responsible for what. So moving on from insurance, we love insurance brokers and all of that too, and we need it, but we've got to address some other issues as well. We want to find ways to increase revenue to reduce that bad debt line item that Mohammed was talking about. One of the best tools that we've found is working. This might not work for inner city or associations where people aren't driving, but I think most of our associations in New Jersey have unit owners who drive, is a parking and towing resolution that allows the association to tow cars of owners who are delinquent on their monthly assessments. It is amazing how quickly someone is motivated to get into a payment plan when they suddenly can't park at home. And these are effective. They're enforceable. I mean, there are contingencies, but you know, we could handle those on a case-by-case basis that might change whether or not this works for your association or certain parking spaces at your association. Great tool. Another one is the leasing and assignment of rents amendment. This is basically a shortcut to a rent levy. Allows or empowers the association to collect rent directly from the tenant of a landlord owner who becomes delinquent in their assessments. Capital contribution amendment. A lot of associations collect capital contributions. They don't all have the authority to in their governing documents. That creates a real problem, or it's extremely low. It was set early on by the developer. Associations, condo associations, can collect up to 9 months of current assessments as an initial capital contribution. It's just a great injection into your finances to help boost the budget, to help address things like unbudgeted expenses so that they don't ruin your budget, and like that bad debt line item. And then finally, amendment to establish the authority to collect late fees, fines, and to allow you to accelerate the entire year of assessments in the event of a delinquency. We see so many clients, especially new clients, charging late fees when they don't have authority in their governing documents to charge it. The Condominium Act for condominium associations, where this is primarily a problem, requires that the authority to charge late fees be in the master deed or bylaws. If it's not in there, we have a real problem. We shouldn't be charging them. We can't collect them. So we need an amendment to authorize that. Fines, it's really a great negotiating tool. I don't know how much money you're going to make off fines, but I have seen some pretty hefty fines get paid, primarily in 55 and over communities when people had their grandkids living with them for a little too long and they decided the fine was cheaper than a hotel or rent on an apartment. And the acceleration amendment is a great tool, moving into the next slide, to shore up your liens. Otherwise, when you file a lien, it's a snapshot in time of what somebody owes the association. Lien is a great tool for associations in collections and addressing this bad debt line item. But if you don't have the ability to accelerate and to have a lien that covers the rest of the association's fiscal year, it's the next month that rolls around, you're undersecured. So we recommend that clients who don't have it implement an acceleration amendment to their governing documents, and then that they update their liens annually. It's a sort of bankruptcy protection. For the most part, liens either survive a bankruptcy or they get paid out in the bankruptcy. There are some exceptions, of course. It also gives you that magic 6-month priority, assuming it was filed ahead of the mortgage company's foreclosure and lis pendens for a condominium association. 6 months isn't a lot, but it's better than nothing. And it also forces a settlement for a refinance or a sale, especially a short sale. You're standing in the way of clear title when somebody's going to refinance or short sale their unit. By having that lien in place, you force a settlement negotiation. It doesn't always result in the full lien getting paid, but it results in money typically coming into the association, and in the event of a short sale, hopefully a new paying owner. Money judgment actions. I'm going to blow through these. I know time's running down and we want to get to your questions. Once we have a money judgment, there are a lot of tools to collect on it. If someone has a job, one of the best ways to get a steady stream of income flowing from that person is to garnish their wages. You can take up to 10% of their wages if they make enough money, and that's going to come in every month. It's going to go to the court officer or the sheriff. They're going to take their 10% cut, and then they're going to forward the rest on to the association until the judgment is satisfied. So hopefully you have a lot of employed delinquent unit owners. Levying on bank accounts is great if you've ever been paid by the unit owner. Your attorney would love to see a copy of a check, a copy of the ACH form that says where the person banks. We'll go straight to that bank to start an effort to levy on bank accounts. You can levy on rents if they have tenants. It's not a lot of fun, but we can take vehicles. Gets a little hairy sometimes when you take someone's car, but assuming that a debtor has a nice enough vehicle to satisfy the judgment and it's not liened up or leased, we can come and take it. It even has been found recently, this is sort of a newer thing, I don't think it's been done a lot, but in the last few years, is levying on home equity with a reverse mortgage. So that's kind of a unique thing, but in a reverse mortgage situation, you know, someone's getting usually payments or something like that from a lender on this funky reverse mortgage thing. So for 55 and over communities especially, where they're more likely to have these, there's an opportunity for the association to go in and tap that equity that's coming to them as an income stream. Obviously, we're always looking to get settlement agreements or file stipulations of settlement with the court that memorialize the agreement with the court. That also gives us the authority, if somebody misses a payment, to go in, get a judgment right away, and go back to the garnished wages, levy on bank accounts, and all of that. And finally, and one of the things that we've been doing a lot in the last 5 or 6 years, is selling the unit itself with a money judgment. It's the last resort. We have to prove to the court we've done everything else we can to find personal assets. But if we've done that and we show the court that we've done that, not an extremely high bar, but you've got to do your due diligence, you can actually sell the unit to satisfy a money judgment. Finally, vacant units. You think they're a nightmare. I think they're an amazing opportunity for you to generate income, either from pursuing the mortgage company in the event the mortgage company has taken action that will constitute possession, so that usually includes changing the locks, winterizing the unit, and you usually know this happened because they put a handy sticker on the door for us. So property managers, board members, take pictures of those stickers and notices and email those pictures to your attorney. We can go after the mortgagee, and we frequently get paid in those situations. And the good news is you're going after a bank, which has money. Your debtor didn't have any money. If the unit is not winterized, in other words, it's not in the bank's not in possession, rent the unit. If it's in rentable condition or it doesn't take a lot of money to rent it, we can ask for a quick claim deed. Some people would love to just get it off their back. It's amazing how many people have given our association clients a quitclaim deed to their unit. We go in and rent it. We take a deed in lieu of foreclosure, and now we're generating rental income. You can accept an assignment of rents agreement. It's not ideal, but basically we put the association in a position where you get to step in and collect the rents if the landlord will agree to it until the delinquency is cured. That's great. $1,000, $1,500, $2,000 a month is usually a lot better than your typical settlement agreement payments. And we can also go after rent receiver orders and receivers in native execution, which what that is basically authority from the court to go in, even though we don't own the unit yet, and take possession, rent the unit, collect the rents, and make the association whole. I will add as a footnote to the rent receiver, I have yet to see a situation in this environment where it wasn't a good idea to finish the foreclosure so that you're not stuck in no man's land of suddenly having collected more rent than the debt that was owed, and now we have a funny situation about the authority to keep the rents, where the rents need to go, versus if you're the owner of the unit, you got a lot better claim to all of the rents, even once you're in the black. And you might pay some taxes on it, but it's better to pay taxes than not have the money in the first place. So that was it for me. I think I finished on time, and now we're going to address some of the questions you guys have sent us.
Thanks so much, Scott. While we're going through the questions, I just want to have the slide up there, so this way you do have everyone's contact information, so if you need to jot that down. So a couple questions. We'll start with Mohammed. And this might be Mohammed or Scott might want to weigh in on this also. If there's a surplus in prior years and the bylaws require you to apply it to the next year budget to reduce assessments, does the board have the option to not follow this requirement? Is there anything that you're aware of in that regard?
Well, it sounds a little legal, but I do think that you would have to. If your bylaws tell you that you have to, you do. I do want to mention that there might be some tax implications to this. If an association has surpluses and is filing a regular 1120 tax return, then you have to keep that in mind, because the IRS does not view associations here to be making money. You're not supposed to be generating and keeping surpluses. The only monies that the IRS allows you to keep is the replacement fund, and that also they have certain guidelines you follow. So you have surpluses and you're filing 1120s, you do have to utilize those surpluses within the next year. But Scott might weigh in too.
Yeah. My general rule is follow your governing documents, and let's talk about a way to change them if you don't think they're ideal. So sort of answering in this vacuum, I would say if that's what your bylaws require, you should be following the bylaws, or you should see it coming. Possibly you can do a mid-year budget adjustment to move that surplus somewhere so that you don't actually have one, as a strategy. But otherwise, let's follow your documents, but change them if they're not ideal. Some of them are dated, some of them aren't ideal, and they need to be changed.
Okay. There are a lot of questions on the towing issues and what you can really do with regard to trying to enforce the paying of the fees.
Right.
So the first question has to do with, does the homeowner association have to follow the Predatory Towing Act in terms of signage in the community with respect to the resolution for parking?
Yes, so you're still going to have to put up those beautiful signs. I actually have associations that don't tow just because they think the signs are so ugly they're not willing to put them up. So you're still going to have to comply with the Act. I mean, there are some exceptions in the Act, particularly if you have clearly marked assigned parking. That's a different issue, but that's not going to address the towing for delinquencies, so that's a different topic. That's just towing in general. If you want to tow for delinquencies, you're going to have to put up the 36 by 36 sign with all the required information at every vehicular entrance.
So following up on that, if the unit owner, the homeowner, owns their own driveway, and if they're in a homeowner association and your driveway or your property Can the association enter that private property to tow?
We don't go there. If they own the driveway, then they can park there. Unless you have really if you wanted to talk about amending actual governing documents rather than just a resolution that the board has the authority to pass, maybe we could come up with something, but I think you would be on a little bit dangerous ground. And typically what the board has the most authority to regulate is common property. So that would be common parking spaces. If they own the driveway, I'm not going to recommend to my client that they tow off of a homeowner-owned driveway.
So we can't go knock on doors and go in their houses and go take whatever we want, right?
Well, no, I've heard stories, but I try to forget them, and I definitely don't participate in that kind of activity.
All right, there's another question as a follow-up with that, is that can an association prohibit delinquent unit owners from using the association's roadway system? Since that is common property, could you prohibit them from going in on the roads and just not even really allow them to drive in the development?
Haven't tried to do that, and I'm not sure how you would enforce it other than denying gate access. But one thing you can't do is prevent someone from actually getting to their home. I've never tried to do that. We have shut off gate keys and forced people to go to the security guard and that kind of thing, and made it a little bit of a headache. But you know, so maybe they could get dropped off at their house, but they couldn't park there. I would say that would be, especially without a gate, extremely difficult / impossible to enforce. And whenever you're implementing a rule, you've got to think about the practical implications of enforcement. So people have to be able to get to their homes, and it's not something I would try to do aside from the deactivate the gate key, force them to go to the security guard, make it a little bit of a pain in the butt because they're delinquent.
Mohammed, I guess both of you spoke about capital contributions, both Mohammed and Scott. What's the recommended capital contribution language? Sometimes we see amendments that say $500 for a capital contribution. Sometimes it's 2 or 3 months of maintenance assessments. What would be your recommendation and why?
Well, I would personally, recommend that you have it based on your maintenance fees, because then it can increase every time your maintenance fees increases, rather than having a fixed number that after 10 or 15 years really is much less than what you would like to be collecting. This way, if you have it based on your maintenance fees, it keeps increasing every time you increase your maintenance fees.
Mm-hmm. Yeah, so assuming we're doing an amendment where we're choosing the language, I like to implement flexible language that allows the capital contribution fee to be adjusted. So something along the lines of, the association may collect a capital contribution fee on the transfer of ownership in an amount to be established by the Board of Trustees. So that gives the Board authority to, up to the legal maximum. There is, for example, in condominium associations, the current legal maximum is 9 times current monthly assessments. So that allows the Board to adjust the capital contribution fee as appropriate with time, with economics, things like that.
Okay, two more quick follow-up questions on the towing. This is clearly a hot topic here. The first question is that you had mentioned, Scott, that signs need to be on all entrances. Does that include emergency access roads also, or just the general entrances to the development?
So if the emergency access road is blocked or chained all the time, then honestly, I'm not. The Act, well, number one, the Act doesn't specifically address those. It says all vehicular entrances. So if you want to strictly construe the Act, then you would put it there at the emergency entrance as well. However, I haven't seen that come up as an issue. So it's just a matter of, if cars are never allowed through there, it's blocked. The only people who can get in are emergency vehicles, then I don't think you need one there. But a strict reading of the Act says all vehicular entrances, and I'm not aware of a case saying that there's an exception for these emergency entrances. So, so if there's any chance that a homeowner could come through that entrance with their vehicle If it's as easy as getting out of your car and the passenger, removing the chain or pushing the gate, then I would put it there. If only emergency vehicles can get in somehow, then you probably are safe without it. But again, a strict reading of the Act would say that you would put it there.
Okay, thanks. Mohammed, so we talked about, you pay as you go and, accumulating a certain amount of a surplus and paying back a deficit. So what happens if there's a large surplus that's been accumulated and somebody sells their home and moves? Has there been anything in terms of rebating to unit owners their portion of a surplus? Has Scott or Mohammed, have you seen any kind of amendment that says if there's a surplus and someone moves out, they're entitled to a portion of their surplus? Any thoughts on that?
I haven't seen that, but my thinking here is that it belongs to the unit. So when somebody sells the unit, it goes with that. So whatever surpluses there are, whatever funds the association has collected, they get allocated with the unit, not that specific owner. So they sell their unit and they sell whatever surpluses they have with the unit. What do you think?
Yeah, I would agree. I mean, you sold your whole interest when you sold your unit. That includes your undivided interest or maybe some proportional interest in the common property, and that would include a surplus. And usually, unless you have a mandated treatment of the surplus or mandated distribution of the surplus each year, we do a resolution to carry forward the surplus, and it's staying in association funds. Nobody's getting a check anyway, but I agree. It's attached to the unit. It's not a personal thing until it gets distributed.
Okay, we have time for one last question regarding the budget and depreciation expense. And should depreciation be a line item in the budget? And how do you know whether or not you should be putting depreciation in the budget, and if you should have capital improvements in the budget or not? Okay. What would be your take on that?
So, first of all, to depreciate something, that means you have to have a fixed asset on the books. Now, as we all know, that the association's common elements are not a fixed asset on the books, depending on whether you're a homeowner association or you're a condominium. But in both cases, you don't have fixed assets on the books at the time when the association was formed. So if you're buying certain capital items, there's two things that you do need to consider. One is, does the item have a useful life that's greater than 1 year? And so that means it can technically be capitalized. The second item that you need to consider is, does that item have a separate resaleable value? So if you, for example, if you have a car, the association has a vehicle that has a separate resaleable value, it has a useful life greater than 1 year, you capitalize that and you do have depreciation on that. But if you're replacing the roof on the association's building, you can't take that roof and sell it on its own. It has no separate value. Therefore, you don't capitalize that item. And since you don't capitalize that item, you do not depreciate the item. The other thing is that the IRS recently came up with the de minimis rule, whereby any individual item that you have that you purchase for less than $5,000, you can expense that, and the IRS would not look at it if they ever needed to, or if they ever came up and decided to do an audit of the association.
Okay, thank you very much. I think that's pretty much all that we have time for today. So we want to thank everybody for joining us. I know we didn't get to all of the questions. Hopefully we got to enough of your questions. If you still would like any kind of follow-up, then we have email addresses for both Scott and Mohammed, so feel free to send them an email. Their websites will also have further information on various topics. Additionally, we will be sending the webinar, so you will have that. So in case you missed something, you will see the slides that were presented in the webinar. Again, thank you very much for attending. We hope that you found it to be a useful amount. You've gained useful information and a good way to spend your lunch hour. So thank you very much.